Hi, friends. I want to walk you through today's agenda. We have been working through the origins of the judicial system, and hopefully, prior to seeing this video, you will have read the annotations in Fed 78. So I'm asking you to annotate the annotations. I think talking about what Hamilton is saying in Federalist Paper 78 really reminds us about some thinking about the court, and I think it's really important in light of conversations folks are having about the court, for us to be thinking about Hamilton and what he has to say about the court. And then really the focus of this screencast is going to be on the Judiciary Act of 1789. Lastly, you're going to get a document today about which court, and it's going to walk you through components of the court system and help build your vocabulary on the court. When we come into class tomorrow, we're going to do some scenario activities. You're going to have to identify what kind of court would be the perfect court for that problem. What I want to have us walk into today is kind of continuing on the origins of our judicial system. And we've talked about the English experience with law, and we've, of course, spent some time on Article 3 of the Constitution. You've just read Federalist 78, and so I want to wrap up today with the Judiciary Act of 1789. One of the things I think is really interesting about the Judiciary Act of 1789 is, as we know, the framers of the Constitution largely didn't have a ton of debates about Article 3 and what the court system is going to look like. And they had some strong reasons for a decent background on the court for reasons we've talked about on Monday. But there are still some things that have to be taken care of when it comes to the court system. And that gets dealt with in the Judiciary Act of 1789. We learned on Monday that Congress has the right to create inferior courts. Article 3 sets out that there is a Supreme Court. And that Congress can create inferior courts, but basically it leaves it at that. What the Judiciary Act of 1789 does is it actually creates those inferior courts and fleshes out a little bit about the Supreme Court and how it's going to work, and like who gets to sit on it, that sort of thing. So let's spend some time looking at this act. I do want you to note in your notes, and just continue on your notes from yesterday, I do want you to note that it is the very first law passed by our very first Congress under the U.S. Constitution. And so I think that's just a fun fact. What it does is it establishes this complete system of lower courts in order to support the Supreme Court. And it says that the job of these courts is to interpret and apply federal law. So I'm not talking about state law or local law. We're still dealing in the realm of federal law. So they are going to interpret and apply. That's their job. Essentially, this act kind of has two purposes, right? It structures the federal system of courts by fleshing out these provisions of Article 3. And some of that includes establishing kind of really the makeup of the Supreme Court. And we've learned that there's some missing information in Article 3 about what the Supreme Court is actually supposed to look like. So it fleshes that out. It fleshes out what circuit courts are going to look like and what district courts are going to look like. So let's first talk about the Supreme Court. The Judiciary Act of 1789 establishes that the Supreme Court is going to have 6 members. It uses the word chief. Right? It establishes that there's a chief justice of the Supreme Court. That person is in charge of the court. They manage the court. And at the time, it says that there's going to be 5 associate justices. So a total of 6. And every now and then people will ask questions like, oh, should there never be an even number? Honestly, there have been plenty of times in American history where there have been an even number. If there's a tie at the court, the rule is that the previous decision stands. So if a case comes to the Supreme Court, and the decision is 4-4, whatever the court before the Supreme Court that heard that case or reviewed that case, that decision is the one that stands. There's no ability to reverse or anything like that. So there have been plenty of times. And even still now, we have a court of 9 that's been the case since 1869. Our court of 9, from time to time, will have somebody step out and decide that they can't engage in decision making for a variety of reasons. Maybe they were sick at the time, maybe they have some personal ties. So we even still, with a court of 9, from time to time may have a court of 8 deciding a case. So I just don't want you to think it's an issue that it's even or odd. Under the Judiciary Act of 1789, 13 district courts are created. And these district courts are basically aligned with each state. So under the Act, every state has its own district court. And each district court then is presided by one judge and is staffed by 2 Supreme Court judges or justices. So still today, that is the case where every state has its own district. May have more than one, but at minimum, it has to have one. So here in Washington State, we actually have 2 districts. We have the Western and the Eastern District. For example, the Western District is in Seattle, the Eastern District is in Spokane. It is overseen largely by a Supreme Court justice, not by 2, because that's a lot of states now versus what it looked like in 1789. Each district at the time of the Judiciary Act of 1789 was broken into regions. It doesn't quite look like that today, but they had sort of smaller areas within a district. Again, a district is a state at that time. Within each district to kind of ride circuit that go from place to place to place in order to not have people come to the court, but rather the court go to the people, if that makes sense. Essentially what the Judiciary Act of 1789 is trying to do is also not only flesh out the court, but also define the parameters of which the court can work. So it sets rules on what the Supreme Court can and can't do. It talks about what district courts can and can't do, what appellate or circuit courts can and can't do. So for example, at the time, now this looks different today, and I think that's important worth noting, that at the time in 1789, circuit courts, they were trial courts, right? A trial would occur, and these would be big trial, like big criminal issues or felonies, capital cases. A capital case by definition is one that could result in death of the person who's convicted. So these are those kind of cases that would be heard at the circuit court level. That's how it was designed in 1789. It's shifted quite a bit over time. Today, circuit courts rarely deal with trials at all. In fact, they don't have trials. Those trials take place at the district court or the lowest court in the federal court system. We do know that under Article 3 and also under the Judiciary Act of 1789, that the Supreme Court could hear appeals from states. Meaning if the state of Kentucky has a state Supreme Court, which they did, and we'll talk about those courts here shortly. They have a state Supreme Court, which deals with state laws or local laws. If a decision came from a state court and a person felt like they were wronged by their state Supreme Court, they could ask the U.S. Supreme Court to hear their case and to review it, is the language we use, and to consider appealing the decision and reversing it. You'll learn a little bit more about that in kind of the reading that you're going to be doing here shortly. I think all in all, as we begin to dig in here on the judicial system, I really just want you to see that these 4 components, English experience with law, the Article 3 of the Constitution, Federalist 78, and the Judiciary Act of 1789 are all the foundations for our judicial system. Obviously, our system grows significantly over time and looks a little bit different than what it looked like in 1789. But it's best for us to understand that foundation, because when we wonder about what courts do and what they're allowed to do and what they're not allowed to do, we always come back to what is it that the framers thought about the court system? Is that thinking that should hold over time, or is it antiquated thinking, meaning old or traditional? And that's something I think that we're debating still in American society today. So I hope that you have had a great day. It's sunny outside, and I will see you in class on Wednesday.